it's a great opportunity to talk a bit about the EPBC Act. I want to focus on that. There is obviously more focus, frankly, in the environmental protection area on some of our climate change laws, and a great deal of interest in Labor's climate change policies that will be taking the 2016 election. I'm happy to take any questions on them and the interaction between those policies and this area of law and policy if people are interested, but I don't propose to address some of the points about market trading schemes that Alan talked about in his speech. I am keen to talk about particularly the future of the EPBC Act because, as Alan, I think, suggested in his speech, environmental protection is or has been one of the most significant fault lines in our federation, at least in modern political history, which I date to the election of Gough in 1972. And although it's the heat in that debate had subsided for a decade or a decade and a half, Alan has also pointed out that it has re-emerged as a very significant fault line between the Commonwealth and the states, between the different political parties, and certainly between the business community and the environmental protection or the ENGO sector. So I do want to talk a bit about the context of that. As with most fault lines in our federation, or at least in our modern federation, the origins of this fault line can be traced back to Gough. Before Gough, there was no Commonwealth activity largely in environmental protection, and although so much attention focuses on some of the very big social policy reforms of Gough's relatively short time in government, his record in environmental protection was quite extraordinary, and with his passing late last year, both in the House and I know in the Senate as well, we had occasion to reflect, I guess, on Gough's record in this area. During his time in the Duumvirate with Lance Barnard, he was the Environment Minister for 2 weeks, which is slightly shorter than my time as Environment Minister, which was a whopping 7 weeks, which I thought was the shortest duration any Environment Minister had held the office in the history of the Commonwealth, but Gough had 2 weeks. And I then found out that Jim Cairns had 2 days. After he was removed from the Treasury position, Gough put him into the environment portfolio and then woke up one morning and decided to remove him entirely. So Gough had 2 weeks to start some ideas and then hand it over to the incredibly energetic Moss Cass, as you know, for 2.5 years, and really set the foundation, I think, for what we now understand to be the Commonwealth role in environmental protection. And the most, I guess, notable part of that period, if not the most enduring, but the most notable part of that period was the famous fight with Joe over drilling for oil in the Great Barrier Reef, and Gough's insistence that the Commonwealth would determine, that the national government would determine the fate of such an important national, if not global, environmental asset, the Great Barrier Reef. You know the story of the Season Submerged Lands Act, which was contested in the High Court and upheld by the High Court on the basis of one of Gough's 2 favourite provisions in the Constitution, the external affairs power, the other one obviously being Section 96, which he used as well. From there, Gough did a whole range of other things. We were one of the first countries to sign on to the World Heritage Convention, onto a range of other conventions under Gough, including the Ramsar Convention. Importantly, he also started to project Commonwealth market power by requiring environmental impact assessments for any projects involving either Commonwealth funds or Commonwealth land, setting the basis for the system that we now have under the EPBC Act. Gough, having done all that over 3 years, and in spite of the fact that Malcolm Fraser, to his credit, cemented the arrangements in the Great Barrier Reef Marine Park and the authority, the extent of Commonwealth reach, as you know, remained very controversial and highly contested over coming years, including during the Hawke government, again with the High Court upholding the Commonwealth's role on the basis of the external affairs power in the Franklin Dams case. But again, a very serious level of contest between Commonwealth and state governments, between the business sector and environmental groups, out of which I think really sprang the Greens Party and Bob Brown. It wasn't until 1992, really, that something of a truce was negotiated by, of all people, Paul Keating, not known for his truce and peace settlement attributes, but the truce in the IGA largely started to demark roles between the Commonwealth and the states and territories, which, as Alan said, ended up being encapsulated, if you like, in the EPBC Act by Robert Hill in 1999. And although the rumblings about the Commonwealth having any role in this area were never, as Alan said, far below the surface, there was for some period of time some broad acceptance that the idea of matters of national environmental significance should demarcate the role of the Commonwealth in terms of environmental protection. And it's important not to overstate quite what that level of reach is. Although the Commonwealth, under existing arrangements, does involve itself in the really big projects by way of environmental impact assessment and ultimately approval, I think, from memory, in my long time as the Environment Minister, I think that number's about 400 to 500 per year, compared to the many tens of thousands of assessments and approvals that are undertaken by state authorities, often at a very much smaller and lower level. When we were in government, as Alan said, we did not change that broad framework. The idea of the Commonwealth having jurisdiction over matters of national environmental significance and undertaking essentially project by project environmental impact assessments and then approval by the Minister. We did not change that basic framework, which Alan reflected on, and I guess having lost the election, we are also in the process of reflecting on. There were, though, I think, some important improvements, as Alan said. The water trigger, which doesn't only apply to coal seam gas approvals, as Alan indicated, it also, as we know, with Shenhua, applies to major coal mines as well, particularly or relevantly here in New South Wales and in Queensland. That was, I think, a very significant improvement. And we were in the process, particularly before the election campaign, of discussing, and I said this in the campaign, the possibility of an expansion of the definition of MNES to include national parks as well, which would obviously be a discussion that required a fair bit of detail with the states and territories, business sector and the broader community. We also did start to have a focus on more strategic assessments that started to develop the notion of cumulative impact rather than the project by project assessment and approval framework which is set out in the Act. And I think everyone understands, well, most people understand that idea of project by project assessment, its inability really to come to grips with the idea of cumulative impacts is a major shortcoming of the EPBC Act. And I think there is much still to do in that area, but I think we made a good start there. And we also started to look at the idea of threatened ecological communities. In my time as Minister, I can't remember what the word is I declared the River Murray below the Darling to be a threatened ecological community, which would require any significant project in that area to go through a relevant process. A matter which caused some quite extraordinary political blowback, given that this had been a matter under discussion by the committee, by the Threatened Species and Communities Committee, for a matter of years. This led to some quite extraordinary political pushback, and unsurprisingly perhaps is a decision that has been since overturned by the new government. So there was, I guess, a decision by our government to keep the broad framework of Robert Hill's in place, make some important, but I think you could probably say incremental improvement to the way in which that framework operates. Having said that there was some broad agreement between the two major parties about the EPBC Act framework. It is quite clear, as I'm sure Larissa will talk about as well, that these issues are now a highly contested area in public policy, particularly at the federal level, but also at the state level, in some states more than others. And before I address our view about that and what that means for the future, I thought I might just deal with a couple of major themes that run very heavily through this current debate, and frankly have run very heavily through the debate over the last 40 years about quite what the role of the Commonwealth should be. And the first is the idea of the role of the Commonwealth in the 21st century within our federation, particularly in the area of policy making, finance and regulation. I differ with Alan about his, I guess, premise about the role of the states and territories here. That's probably not surprising, given I'm a Labor MP and I'm a federal MP. But the consistent thread through all of Goff's policies, and in a significant sense Labor's approach to federalism over the last 40 or 50 years has been to assert the role of the Commonwealth, to assert the idea that in so many areas, particularly in terms of policy making and regulation, we are one nation. I know that's a phrase that isn't as popular as it once was, but we are essentially one nation. And in the 21st century, more than any time in our history, it is important for us to have a consistent national approach to some of these very, very important questions. We know that since the engineers' decision, there has been an inexorable shift towards Canberra in terms of those policy making, financing and regulatory responsibilities, and I think that that overwhelmingly has been a good thing. And in spite of the fact that this government is trying to push back on that in this area and some other areas, we're still seeing very recent examples of where the community wants the Commonwealth to play more of a role in areas that were traditionally reserved to the states. The most obvious examples, I think, are the National Disability Insurance Scheme, where families for decades had very rightly complained and advocated about the poor effort by most states and territories in disability services, and ultimately came to the view that they weren't going to do better without the Commonwealth stepping in, using its financial power, but also its capacity to do very good policy making, which I think we saw on a largely bipartisan basis over the last couple of years. And Larissa wouldn't have been able to revel in the joy of this, but Christopher Pyne told us in the House of Representatives yesterday in question time what a major achievement it was finally to establish a national curriculum for our schools. A Labor initiative, I might say, but the idea that in 2015 we would have 8 different maths, science, English, history and so on curricula, I think is just utterly ridiculous. It's a ridiculous position as a matter of principle for the country to have been in, but also given that about 80 or 100,000 school students change states and territories every year, the idea that they have to change curriculum, I think, has also been ridiculous. So there is, and there should be in the 21st century, a strong bias in favour of the Commonwealth, the national government, taking policy making, financial and regulatory responsibility for national issues. And environmental protection, I think, is one of them. That should be the starting point in this debate. The second theme, or as Leslie Zines used to call it, major dogmatic premise in this area, I think, is that the idea of environmental protection on the one hand and economic prosperity on the other are mutually exclusive, that they are a zero-sum game. The more you have of one, the less you have of the other. And the other major dogmatic premise here, which you will particularly hear from business organisations, obviously from the Minerals Council and other resources organisations, but increasingly too from the Business Council, is that Australia leans far too heavily in favour of environmental protection at the expense of our economic prosperity, particularly you people who revel in the use of green tape, that you are strangling the economic prosperity of this nation. Now this was shown by those left-wing conspirators at the OECD only a few months ago to be utter bunkum, in a phrase that only the economists at the OECD could come up with. They published their Environmental Protection Stringency Index a few months ago, which rates, has a very complicated modelling system that I have to admit I don't really understand, rates the environmental protection laws and regulations in all of the OECD member states, rates them from 1990 to 2012, and rates them according to their stringency. And it's very clear from that Australia's stringency in 2012, and we've lost a lot of environmental protection since that time, but even in 2012 was way below the OECD average, was below pretty much every country that we usually compare ourselves to. The US, the UK, Canada, Japan, Korea, Germany, France, all of those nations were found by the OECD to have not just more stringent, but significantly more stringent environmental protections than ours. The other very important finding from this OECD report, I think, was that there was, tracking over a long period of time, a positive correlation between environmental protection and economic productivity. Not a zero-sum game, but a positive correlation, certainly in the medium to long-term measure in productivity, for the very obvious reason that history shows that environmental protection measures lead firms either in the short term or at least ultimately to improve the way in which they operate, and usually to become much more effective and efficient in the way in which they operate, thereby contributing to national productivity. So as we continue through this debate about whether we should water down environmental protection in Australia, whether we should hand things over to the states and territories, we should, I think, debunk these major dogmatic premises that continue to overlay this debate. The idea that environmental protection necessarily reduces economic prosperity, and also the idea that the states and territories should still be allowed to operate 8 different schemes of environmental protection in a modern economy and society like ours. As Alan said, I think, and certainly as I've experienced, and I'm sure Larissa has, that for a few years now, the business sector has been undertaking an extraordinarily ferocious lobbying effort to try and get the Commonwealth to hand over its powers. I can say with the luxury of opposition now that when I was made this minister and when Kevin returned to the Prime Ministership, the Business Council put this issue at the top of their list. The top of the list of all of the issues they thought were important for the Commonwealth Government to address in the area of economic regulation, national productivity and the like. Handing over our environmental powers to the states was top of the list, which I found extraordinary. But they haven't let up. There is still a very ferocious lobbying effort going on. It tends to operate on the basis of the argument that duplication between the state and the Commonwealth systems costs them a ferocious amount of time and money. As I said, it's dragging down Australia's economic prosperity because of that. And there is no question that duplication of process is an ongoing challenge for a federal system that often has 2 levels of regulation at state and Commonwealth level. We have said throughout this debate for a few years now that there is significant merit in trying to streamline assessment processes between state and Commonwealths where there are projects that trigger both systems. For example, there is no reason in my mind why there couldn't be a single environmental impact assessment process, provided that the Commonwealth and states were confident that the terms of reference for that process satisfied both systems. There's no reason in my mind why there couldn't be one public consultation process. We are up for that discussion. When we said we were up for that discussion, the fact that we said it didn't include a handover of approval processes meant that other state governments, particularly the O'Farrell government here in New South Wales, and the Business Council pushed back from the table and said they weren't interested in just discussing assessments. We do have the view, though, that as a matter of principle, and for practical reasons I'll go into, but as a matter of principle, the national government, whether it's Liberal or Labor, should have responsibility ultimately for protecting matters of national environmental significance. And I want to stress that this for us is not a party political position. It's a position that I, as a South Australian, for example, disagree with the state Labor Premier on, who happened to be the best man at my wedding and I was best man at his wedding. We disagree on this. I would rather that Greg Hunt had approval powers for matters in South Australia that touched on matters of national environmental significance than a Labor state Premier. That is an important matter of principle, which frankly we had a debate about over the last couple of years, but which Labor has reached a very, very conclusive view about now. There are also very practical reasons why we shouldn't do this handover. There are, I think in spite of some of the comments that Alan made, some very serious questions over the capacity of state and territory systems to handle the complexity of some of these projects, and particularly the complexity of the protection of some of these matters of national environmental significance. And that's not to say that the Commonwealth is good and the states are hopeless. It would be impolitic for me to say that. It is just because it is demonstrated that some of the state systems do not have the capacity to deal with these systems. The Auditor General reports on the Queensland Government's approach to environmental protection, I think, have been damning. The Western Australian Government's approach to James Price Point was hopeless. I think just in terms of capacity, as state governments wind down their environment departments, there are very serious questions about what the impact of this from a practical point of view would be. We also know that many of the matters of national environmental significance are by their nature national. I have a view that the Great Barrier Reef is not just a Queensland asset, it is a national asset. It's probably a global asset, but it's certainly not just a state asset. The idea that Greg Hunt would hand over the responsibility and power to protect the Great Barrier Reef, not just to the Queensland State Government but to Queensland local councils, I think is a terrible abdication of our national responsibility. But there are also very significant matters that simply cross state borders. The Great Artesian Basin is an obvious example. There are downstream impacts that a state government like Queensland, for example, is simply not able to deal with properly, which will be to the detriment of other states that are downstream. And I think we need to be frank that the appearance of a level of distance between project proponents, community debates about projects, fundraising lunches and all of those other things which are notorious here in New South Wales, maybe more than any other place in the Commonwealth, there is an importance, even if not as a matter of substance, then as a matter of perception, that there be, particularly with some of these very, very significant projects, a level of distance that only a Commonwealth approval, I think, can give, which is, I think, another very important reason to keep in mind. Ultimately, though, there's been no economic case mounted for this. The BCA has never been able to demonstrate to me, or I suspect to Larissa, who's nodding furiously, that there is a clear economic case, particularly around approvals being handed over. I think there is a case for us to consider around assessments, but the approval power, there is no economic case being made, and I think it is completely notable that I've never heard Greg Hunt once try to make an argument that this will improve environmental protection. Never once has this government, whether it's the Prime Minister or the Minister, stood up and even attempted to make the case that this will lead to better environmental protection. It has simply been addressed on the basis of the Business Council's view. That is why we'll be opposing this. That is why we'll continue to oppose it, and will be a very important backdrop against which we undertake the process from here on in around policy development. Our policy development process in this area, as in so many others, is heavily framed by an understanding that we got a shellacking in late 2013. And when you take a significant election loss like we did in 2013, and you have leadership change, there is inevitably a root and branch review over our approach to pretty much every significant policy area, including this. The Hawke Review is a really good document. I've had a very close look at it. There's some very good stuff in there, and that informs a lot of my thinking about the EPBC Act. But I want to indicate to the Law Council, as I am to other stakeholders in this area and the community more broadly, that we have a very open mind about the idea of future environmental regulation. We do have a strong view, which we will maintain, that the Commonwealth does have a role. The Commonwealth does have a role that is broadly circumscribed by the idea of matters of national environmental significance. But quite what the framework of Commonwealth legislation should be, we do take an open mind over the course of the next several months as we develop our election policies. And I very much look forward to continuing discussions with groups like the Law Council and many others about what a 2016 election policy for Labor in this area might look like. Thank you very much for the opportunity to be with you, and I look forward to the panel session. Thank you.